Good morning, everyone, and you're all very welcome to today's webinar on the Work-Life Balance and Miscellaneous Provisions Act, brought to you in association with the Greater Dublin Alliance. It's great to have you all here this morning. I'm going to hand over to Anthony Cooney now, who will do a short intro.
Thanks, Sarah. Good morning, everybody, and welcome to all attendees here this morning on this webinar with Adare Human Resource Management. To all of you who are members of Dún Laoghaire Chamber of Commerce, County Kildare Chamber, and indeed our own here at Fingal Chamber, I'd like to welcome you all to it. To those of you who are not members of your local Chamber of Commerce, doesn't do the sales pitch, it'd probably be a good idea to join up. Chambers of Commerce, the three Chambers of Commerce here this morning, work closely on a lot of issues, and we have members who cross into all of the areas. Your local chamber brings you the benefit of representing you at local and national government level, and we help organize events, various social and business events. We operate a skill net, which is, for those of you who don't know, it's an enterprise-led training initiative that's underpinned and funded by the training levy imposed on government on all businesses. So you're availing of that when you benefit from a skill net. And we also, of course, coordinate information events such as this morning's with the Adare Human Resource Management. So without further ado, I'd like to hand you back over to Sarah Fagan, the Managing Director of Adare.
Thank you so much, Anthony. And it's great to be here working in conjunction with you, in particular when there's so many legislative impacts to businesses in the Greater Dublin Alliance area. And it's so important that as organizations and businesses seek to align to compliance, that we are, informing your members in relation to the most up-to-date information that is required by all these legislative changes. So essentially, as I mentioned, we're dealing and discussing this morning the Work-Life Balance Miscellaneous Provisions Act. And with that, there has become a number of sort of issues and challenges that are rising within businesses as they look to ensure that they are compliant with the legislation. Essentially, if you recall, approximately 12 months ago, there was a heads of bill in relation to the right to request remote working, which has since been integrated with the Work-Life Balance and Miscellaneous Provisions Act. So there's a lot of changes that have occurred over the course of the last 12 months in relation to this particular area. But the legislation itself actually stems from a European directive, and essentially what we're going to look at is just a brief introduction and background in relation to that. Then we're going to go through the act itself and the overview and key actions, more importantly, that all employers can start to take in preparation for the commencement of the various provisions of the legislation. I will, of course, ensure that there is time at the end to allow for some questions and answers. So please do feel free to include any questions you may have in the Q&A function, and we'll take time to just address those at the end. So to kind of get started, obviously, it's really looking at the background and the purpose. So the Work-Life Balance Miscellaneous Provisions Act 2022 transposes Articles 6 and 9 of the EU Work-Life Balance Directive into Irish law. With that comes the provision of a number of new rights for employees to better support a balance of family life, working life, and caring responsibilities. Now, what the government have done and the legislators actually introduced additional provisions under this piece of legislation that supplement the EU directive. And essentially what I'm referring to there is the domestic violence leave and obviously the right to request remote working, which is now seen as a form of flexible working. And I'll take you through what that looks like later on in the presentation. But with this piece of legislation, there are a number of amendments to various acts of employment law, including the Parental Leave Acts, Maternity Adoptive Leave Acts, Family Leave Acts, and so much more that I won't mention. And for organizations and businesses seeking to understand what are the key actions that they should take in relation to this important piece of legislation, I'm going to inform you in terms of the preparation that you can do now to ensure that there is compliance and the various steps that you have to take. But to give you a high-level overview initially in relation to the new rights and entitlements, the Work-Life Balance Miscellaneous Provisions Act essentially provides for leave for serious medical care, leave for victims of domestic violence, a right to request flexible working for caring purposes. Now, there are limitations and parameters in relation to that, and I will bring you through it this morning. The right to request remote working, and then there's been new extensions within the legislation, amending various pieces of legislation, such as the Maternity Leave Act and Adopted Leave Acts, in relation to the extension of breastfeeding breaks and extension of maternity leave access to maternity leave. And I'll bring you through that as well. So we're going to get started with the leave for serious medical care and what that means for organizations, both from an employer and an employee perspective. So essentially what the Act lays out is that there is a new entitlement to 5 days in any 12 consecutive month period, where any employee who's availing of this type of leave and say, for example, they take less than a full day, it will be considered a full day out of the 5-day entitlement. And essentially this leave is going to be provided for those employees who are supporting certain people who are in need of significant care or support for a serious medical reason. So that could be an employee who is the relevant parent of a person who's in need of significant care, the spouse or civil partner of the employee, a cohabitant of the employee, parent, grandparent, brother or sister, or a person who resides in the same household as the employee. So essentially, there's a number of things from that as an employer that you need to ascertain when an employee is advising or outlining that they're availing of the entitlement. You do need to understand, is the person who's in need of that significant care fitting into the categories that are outlined in front of you on the slide. From an application perspective, the employee essentially will advise an employer as soon as it's reasonably practical that they are availing of the leave, and they'll provide confirmation in writing. The signed confirmation must include a start date, the duration, and a statement of fact, which relates to the rationale for availing of the leave. From an employer's requirements, you must retain the confirmation document. This is something that you need to keep on file. You need to provide the employee with a written acknowledgement of receipt of confirmation, and that is also to be retained by the employee. But in order to, again, ascertain, why is this employee availing of this leave, you can request evidence relating to the relationship with the person being cared for. Do they fit into that category of people who, are protected, or the protections of the Act will provide the care leave, the nature of the care being provided, and a medical certificate stating that the person named is or was in need of significant care support for a serious medical reason. Now, I would say and highlight that this is separate and distinct to force majeure leave. Force majeure leave remains a statutory entitlement, and that is obviously, again, in situations where an employee has to be present because of something significant that has happened, potentially for a medical reason. And this is a new and distinct right that is essentially ensuring that there's greater balance in relation to family life, in particular when it comes to serious medical care. I would also point out that this is separate and distinct from carers leave. That obviously remains a statutory entitlement, and that will continue on with its own provisions and parameters. So essentially this whole new right and entitlement means that as an employer and as a business, you are going to have to ensure that you're drafting a policy and procedure that is specific to this entitlement. And that's one of the key actions or takeaways to allow you to prepare for the commencement of the provisions of this Act. Now, the second thing that was introduced under this piece of legislation is the leave for victims of domestic violence. And this is something that you would have heard about. There was a lot of press in relation to it. And essentially, it's something that, whilst it's not contained in the EU directive, it has supplemented the piece of legislation introduced by the Irish government and legislature. And essentially, what they have outlined is that domestic violence leave is provided where the employee or relevant person has experienced in the past or is currently experiencing domestic violence. And essentially, the purpose of this type of leave is to enable an employee or a relevant person to seek medical attention, to obtain services or an order from the Garda Síochána, to relocate potentially, or to seek advice or assistance, which could be medical by nature or it could be legal advice. And that is something that this type of leave allows for. So essentially what they have indicated in the legislation is that any employee or relevant person in need of this type of care is entitled to 5 days paid leave in any period of 12 consecutive months. Similar to the leave for serious medical care, if an employee avails of a half a day, that will be considered one full day out of the entire entitlement. Now, by its very nature, and similar to the leave for serious medical care, advance notification may not be possible. So what the legislation has outlined is that an employee must advise the employer as soon as is reasonably practical, and essentially then complete a form, which is something that could be done following the period of leave because of the seriousness of this particular entitlement. The government have actually outlined that there will be payment for this type of leave. And certainly there's a lot of considerations from a budgetary perspective that employers now need to consider. So if you go back to January 2023 with the introduction of the statutory sick pay, what we saw is that there was a mandate for a particular payment that has been made by the employer. The same will apply for domestic violence leave. And within the legislation, the minister can actually prescribe a daily rate of pay. And that is something that could be, and this is very much caveated, could be similar to the statutory sick pay. So it's likely that they will look at a percentage rate of the employee's pay up to a maximum daily amount, or an allowance for board and lodgings, or board only, or lodgings only. And what the minister has indicated is that this is likely to be prescribed within the summer months and potentially before the government recess. So we are keeping an eye out, and obviously as strategic partners with Fingal, Kildare and Dún Laoghaire and Rathdown Chamber of Commerce, we will ensure that all members are communicated with as soon as that becomes common knowledge and it's being published by the government. It will be important again that employers are preparing a policy and procedure in relation to this, but obviously it can't be communicated out or published within your business until we have knowledge of what that rate of pay will be. But essentially, that's something that we will keep you informed on and ensure that you get the relevant information as it takes place. So the next entitlement under this piece of legislation relates to the right to request flexible working for caring purposes. Now, essentially, this is different and distinct to the leave for serious medical care. It's all about flexible working. What form that takes will actually be agreed between the employer and an employee. But essentially, any employee who is a relevant parent of a child and who is or will be providing care to that child for the purposes of ensuring their care will be able to apply for this type of flexible working. Or a scenario could arise where an employee has to provide personal care support to a person to whom the employee is the relevant parent, a spouse or civil partner, a cohabitant, parent, grandparent, brother or sister, or somebody who resides with the employee and is in need of significant care or support for a serious medical reason. So those parameters are, quite distinct in terms of who can avail of that type of flexibility, but it is something that will be confined to those categories of employees. Essentially, the legislation does highlight that a flexible working arrangement for the care of the child in relation to the legislation would be set with parameters of children up to the age of 12 years or 16 if the child has a disability or a long-term illness, or a child who is the subject of an adoption order before they reach 10 years of age. And within the legislation itself, it does highlight that the employees must have completed 6 months continuous employment, essentially to commence the type of flexible working arrangement. Now, it doesn't mean that they have to wait until the 6 months continuous service to apply for flexibility, but it's something that can't be commenced until they've reached that period of time, 6 months service with the employer. And essentially what was really interesting within the legislation, they've also indicated that if an employee, for example, was terminated and, for whatever reason, but then commences or recommences employment with the same employer within a 26-week period, that the time that they were employed previously will count towards that continuous employment for the purposes of achieving 6 months service with an employer. So that's something just to bear in mind when you are assessing any applications to flexible working. The right to request any type of flexible working could mean and translate to reduced working hours or adjusted working patterns. And it's really whatever the employee applies for, but obviously you need to assess it in light of the needs of the business. And it will be limited, as I mentioned, to parents and carers. Again, this is distinct from force majeure leave, carers leave, and so forth. This is really about maintaining employment, but having the opportunity to work in a flexible working arrangement. So from an application perspective, any employee who is seeking to avail of the right to request flexible working for caring purposes essentially must make an application in writing, and obviously that has to be signed by the employee. They must also specify the form of the flexible working arrangement, including the start date and the duration. And any application must be submitted no later than 8 weeks before the proposed start date. In regard from the employer's perspective, the employer can request evidence. So essentially, if it is about flexibility for caring purposes of a child, you can request a birth certificate of the child, or when it comes to an adoption order, the certificate of placement. If it's not concerning a child, but it's a spouse or a cohabitant, any other category that I mentioned previously, you can request details of the relationship and also the nature of the significant care or support needed and a medical certificate. And all of those you must be very cognizant of from a data protection perspective as to the retention periods for that specific information. It should only be held for the purpose of understanding the request as opposed to maintaining it on the employee file. The employee can withdraw by notice in writing before any agreement is signed. And that, could arise where the reason for the significant care has ended prior to the commencement of the flexible work arrangement. Now, in terms of the employer's responsibilities, obviously any application coming in will have to be assessed. And whilst you can, of course, request that information that I've just highlighted, you need to ensure from the compliance perspective that you are responding within 4 weeks of the request. And essentially, what you need to highlight as an employer is whether or not the arrangement has been approved. And if that is the case, you must provide an agreement that will be signed by both you and the employee, detailing the arrangements, the start and end dates, and a copy of that signed agreement must be maintained by the employers and provided to the employee as well. Now, depending on your type of business, there may arise a situation where multiple employees are applying for flexible working arrangements in order to provide significant care to a named individual. And in that regard, it may be difficult for you to assess it. And, essentially, whilst you do need to communicate within 4 weeks of the commencement of the proposed flexible working arrangement, there could arise an issue where you need to continue to assess the viability of the request. And in that regard, you can extend the 4-week period by a further period, not exceeding 8 weeks, in order to assess the viability and determine what type of arrangement could work within your business. Subject to the employee's approval, the response time could be further extended by 8 weeks as well. I would note that any refusal in relation to flexible working arrangements have to be objectively justified in writing by the employer. And essentially, there is scope for the employee to raise a complaint at the WRC. So you need to ensure that it is very legitimate and it's something that essentially, you can stand over, or it can withstand challenge. And because obviously that could be taken further by an employee at a third party. Now, when it comes to termination, or if a concern arose in relation to the abuse of flexible working for caring purposes, there might be just cause for an employer to terminate the arrangement due to the substantial adverse effect on the operation, or reasonable grounds to believe that the flexible working is not being used in the intended manner, i.e. to provide the significant care to an employee. So in that regard, an employer can provide notice of terminating the arrangement in writing no later than 4 weeks of the proposed termination date, but you must include a statement in summary form of the grounds for terminating the flexible work arrangement for caring purposes. Now, within that, I would highlight that it would be really important that there are significant justifications, again, because this is something that could be brought to a third party. And what's interesting, again, in the legislation is that prior to an employer giving notice of the proposed termination, they must highlight to the employee before the official notice is given that they intend to give notice of a proposed termination. And with that, that means that there's almost 2 notice periods, one for the notice of termination, but a pre-stage where you need to give notice of the proposed termination to the employee in writing, including a statement as to why, and allowing the employee 7 days of receipt of the notice to make representations to the employer before a fully informed decision is made. And in that regard, you need to take consideration of any of those representations, and all notices must be retained by both the employer and employee. So in that scenario where an employee maybe was potentially abusing the flexible work arrangement, maybe wasn't actually providing care, and there's, evidence of that nature, then essentially if the employee doesn't have representations to make and you can stand over your decision, then you can give the proposed or the actual notice of termination. Now, it may arise as well because of the very nature of this type of arrangement that an employee requests to return early. So they will have provided an outline of the start date, the end date, the duration of the flexible working arrangement. But essentially, if, for example, the employee who is providing care to a child and the child's health improved and they essentially didn't need to avail of the flexible working arrangement for the entire duration, they can write to the employer and give signed notice of a request to return earlier, setting out the reasons for the return and the proposed date for the return. In that regard, employers have to consider all requests having regards to the business's needs and the employee's needs, and essentially provide notice in writing a minimum 4 weeks after the request, detailing the approval or the refusal. And you need to set out the reasons for both in relation to that. If the situation arises whereby you approve the early return, but potentially the date doesn't suit, now again, you would need to justify why that date doesn't suit. It could be the case that you have hired an employee on a fixed term or a specified purpose contract to cover some of the hours of the flexible working arrangement, and that contract remains in place. And even though you can give notice, depending on the terms of that contract, may not fit or align with the proposed return date of the employee. And in that regard, you need to provide an alternative date. So that's just one example of what could arise in relation to an early return, approval, and the proposed date not potentially suiting the business. There could also arise changes to flexible working for caring purposes. And in that regard, both the employer and employee can agree in writing that essentially, the changes to the flexible working arrangement can be postponed, curtailed, or even varied, but it has to be agreed by both the employer and the employee. Now, moving on to the next area that is coming from the Work-Life Balance Miscellaneous Provisions Act, and specifically looking at maternity and adoptive leave, and essentially what has come as an increased entitlement from that piece of legislation is the right to extended period of breastfeeding. So essentially, both the Maternity and Adoptive Leave Acts have been amended and increasing breastfeeding from 26 to 104 weeks. And that entitlement means it's paid time off work or to have reduced working hours for breastfeeding purposes. You should also be cognizant as an employer that if an employee is availing of the right to breastfeed within the actual work environment, you need to provide a private room and facilitate the employee being able to breastfeed in the workplace in that room. The other extension to the Maternity Leave and Adoptive Leave Acts comes from the right of maternity leave access being extended to transgendered males. Now, in that regard, what the legislation has detailed is that the employee who's seeking to avail of access to maternity leave must have obtained a gender recognition certificate in accordance with the Gender Recognition Act 2015. And in the scenario where that person becomes pregnant, they can now avail of the rights under the Maternity Protection Act 1994. So for those two items, you need to ensure that you are amending your current policies and procedures to reflect this new entitlement. And you also need to communicate that out to your employees. Moving on to a more we could say challenging aspect that has come from the legislation, and that relates to the right to request remote working. So essentially in this regard, we have seen, a lot of news pieces in relation to the right to request remote working. We're also very cognizant of the fact that since the pandemic, most organizations have implemented some form of flexible or hybrid working policy. And whilst that can obviously remain in place and should remain in place, it does mean that you need to either amend that policy or create a distinct policy whereby an individual employee can make an application for a request to remote working that is separate and distinct to the current policy that you have in place. And in that regard, we're obviously waiting for the Workplace Relations Commission to publish a code of practice. And that's something that will hopefully come out and be published in the coming months. I know currently there's a call for open submissions for employers and organizations to actually submit their points or considerations that they want the government to take account of in the publication of the code of practice. But we are waiting for that code in order to actually draft appropriate policies that will align to that specific code of practice. But from the legislative perspective, what it has outlined in terms of the criteria is that employees must have 6 months continuous service. Now, again, when it comes to 6 months continuous service, they have included in the legislation that if an employee has been terminated for whatever reason, but recommences employment within a 26-week period, the time before the termination will count towards the continuous service for the purposes of this application. And in regards to the application itself, a request for remote working arrangement must be put in writing and signed by the employee, provided no later than 8 weeks before the proposed start date, and must specify the details of the remote working arrangement, which would outline the proposed start date and end dates, and specify the reasons for the request. So that could relate to the employee's needs, but it must have regard to the code of practice. There are other details that will be required, such as the proposed remote working location, and any information that will be detailed in the code of practice itself will kind of set out the parameters in relation to any additional requirements when it comes to an application of the right to request remote working. Any application can be withdrawn again before a signed agreement is reached. So that allows the employee an opportunity to effectively change their mind before the agreement is reached with the employer. Now, when it comes to the employer obligations in relation to considering a request for remote working, the employer must consider all requests having regard to his or her needs. So that is the business needs, the organizational needs, also balancing that with the employee's needs and anything that is outlined as a requirement within the code of practice itself. The employer must respond to all requests within 4 weeks of receipt of the application for remote working. And if it's been approved, an agreement with the details of the arrangement, such as the start and end dates, or the location or anything else that's dictated by the code of practice to be included in the agreement, will have to be contained within that document. If a refusal has been made, notice in writing informing of the reasons of the refusal have to be outlined to the employee. Or if there is an extension needed because it's difficult to assess the viability of the request for whatever reason, that reason having to be objectively justified, of course, an extension to consider the request by 4 weeks can be made by the employer. Now, what's really important here when it comes to, I suppose, the compliance requirements, but also the risks that are associated with third parties. Essentially, it is an obligation of the employer to maintain records. So you need to ensure that you are retaining a copy of the signed agreement and the details such as the period of employment, the dates and times of the work arrangement, and that all has to be retained for a period of 3 years. Now, again, I would draw your attention, and it's interesting that the Workplace Relations Commission's most recent report was published probably about 2 weeks ago. And in that, you can see that there has been an increase in the amount of inspections within businesses and organizations. And this is something that I suppose I'm specifically calling out because it's likely that those inspections will continue to increase year in, year out. And in that regard, any WRC inspectorate could attend your workplace without giving notice of their presence, and essentially seek to look at all of these records and the documentation relating to employment legislation. So in that regard, it's really important that you do and you are maintaining adequate records so that you're not subject to a compliance order or any negative consequences by virtue of the fact that you haven't maintained adequate records. It's also an obligation to ensure that the employee is provided with all of the written information, and essentially that the employee retains that as well for a period of 1 year. Now, the case may arise again where an employer is seeking to terminate the remote working arrangement. Obviously, this is seen as a separate flexible working arrangement, but it could arise as well that there is potential evidence of abuse of the remote working arrangement. And in that regard, the employer may seek to terminate due to the substantial adverse effect on the operation of the business, or reasonable grounds to believe that the discharge of the employee's duties are not taking place. So to give you an example, if an employee makes an application for a request to remote work, potentially for 4 or 5 days a week, and it's approved, but the deliverables and the KPIs are not being met, that is something that could be cause and reasonable grounds to terminate the arrangement. But again, whilst an employer can provide notice of terminating this flexible working arrangement in writing 4 weeks before the proposed termination date, outlining the statement of the grounds for terminating, in advance of that, the employer again is obligated to provide notice of the proposed termination to the employee. And similar to the last arrangement that I was speaking of, you essentially need to set out the summary or the grounds for why you're proposing to terminate. And again, you must provide 7 days for the employee to be able and accommodated to make representations to the employer in relation to the proposal to terminate. And any such representations essentially need to be taken account of before you make a fully informed decision in relation to the decision to terminate being made. And all notices must be retained by both the employer and the employee. So again, there's a lot in there when it comes to that aspect of it. But the other areas just to examine before we just consider the compliance requirements and the key actions that you should take away from this morning's session is that an employee may request to return to the previous working arrangement. So effectively, the employee can make an application in writing and request to return to the original working arrangement, setting out the reasons for the return and the proposed date for the return. The employer is thereafter obligated to consider the request, having regard to his or her needs, meaning the business needs and the employee's needs, and obviously the code of practice. And in that regard, the employer must provide notice in writing a minimum 4 weeks after the request, detailing the approval or refusal and setting out the reasons for same. And again, where the proposed date of return is not approved, an alternative date must be provided. Finally, changes to the remote working arrangement may be proposed if both the employer and the employee agree in writing that the proposed remote working arrangement can be postponed, curtailed, or even varied. But again, that agreement has to be reached between both the employer and the employee. Now, finally, in relation to non-compliance and the Workplace Relation Commission and potentially the Labour Court, recommendations could be made in relation to any aspect of the various entitlements if there's been non-compliance. And in that regard, whether it's an adjudication hearing or potentially an appeal to the Labour Court, all employees are protected from penalisation. So the WRC or the Labour Court can direct an employer to carry out a certain objective in relation to any aspect of the provision set out in the legislation, or they could make an award, a financial award, or even both. So in that regard, there's a number of compliance requirements that we've run through this morning. And essentially, I'll come to the key kind of actions that you should take now in preparation for the commencement orders. An award of compensation not exceeding 4 weeks remuneration when it relates to remote working can be made. And in that regard, whilst, depending on the salary of the particular employee, it's still a financial liability and one that you can quite easily mitigate insofar as you're compliant with the legislation. There has been an indicator within the legislation that an award of 20 weeks of remuneration could be recommended by the WRC or the Labour Court when it concerns flexible working arrangement for caring purposes. So if you were non-compliant as an employer, that is a significant risk from a financial perspective, but also the PR implications that can be garnered from a complaint going through a third party such as the WRC or Labour Court. Or essentially, again, if we recall my emphasis on the importance of maintaining the records when it comes to remote working arrangements, that essentially if an employer was found guilty of an offence, they could be liable on summary conviction to a Class C fine. So there's a number of considerations when applications, whether it's for the flexible working, for caring purposes, remote working, retention of records, or if you were to penalise an employee or not provide the statutory entitlement to leave for caring purposes for serious medical reasons or domestic violence leave, that there is an exposure from an employment perspective. And all of this is, on top of the litany of other risks that exist from the employment legislative updates that have occurred over the last number of years. And specifically since the pandemic, we've seen so many changes to legislation and the introduction of new rights and entitlements that it is, a financial burden on the employer. But, the whole purpose of this piece of legislation is to create the balance of flexibility and family life that was seen as an EU directive. So it is something that, whilst I appreciate the significant financial burdens that can come from these types of arrangements, it is something that you need to ensure you are compliant with as an employer. So on the next slide, I've just set out in table format, what the entitlements are, indicating, the various provision of leave, the entitlement, whether it's paid or unpaid, and the category of employees. And obviously this is something that we can circulate afterwards. Finally, I just want to bring you to the key actions. So how can you prepare for this, knowing that this information now needs to be acted upon by all organizations? Certainly, we do think that over the coming months, we will, or even sooner, we'll get an indicator in terms of the commencement date of the different provisions that are outlined in this piece of legislation. So it's a real opportunity for employers and businesses to ensure that they are ready and prepared for it. So if you consider the various policies and procedures that you either have to develop or amend, the first is a development of a leave for serious medical care, and that's a separate policy, as would be the leave for victims of domestic violence. So you need to set out the purpose, the scope, who it applies to, and the entitlements as they are outlined within the legislation. There will also be a requirement to develop a policy on requests for flexible working for parents or carers. And again, setting out the purpose and scope, as well as the entitlement and the procedures that apply from the application process and the employer obligations in relation to consideration of any applications. And then finally, the request for remote working. But I would say that this is the one item that you would need to wait until the Code of Practice is published by the WRC. And again, that could be a couple of months before we get sight of what is contained within that. Next, preparation. So again, In terms of the requirements to retain records, to develop signed agreements and so forth, there's a number of documents that you need to start preparing for, one of which will be the application forms for the leave for serious medical care and requests for flexible working for caring purposes. You should template acknowledgement letters now responding to the caring leave requests. And that's something that as they come in, because there are specific notice requirements in terms of your obligations as an employer to respond to any request within 4 weeks for the majority of them, that essentially you have all of those templated and prepared so that you're not non-compliant in terms of the period of time that you have to respond to any application. You also need to develop then the confirmation documents highlighting the various working arrangements that will be sent to the employee for signature, a copy retained by both the employer and the employee. So in one regard, whilst we are waiting to understand the commencement date for the different provisions, and I do think that those will be staggered by the government, now is the time to start acting on the development of these policies and procedures and preparing all the template documentation that will be needed, that will have to be retained on record by the employer and provided to the employee, so that you have ample opportunity once you get notice of the commencement dates, that effectively you're communicating straight away with your employees. You're obviously outlining the changes to the employee handbook by virtue of these policies and procedures and having all the documentation ready. Finally, when we consider the amendments to current policies and procedures, essentially you need to ensure that you are amending the maternity leave policy regarding the extension of breastfeeding breaks, again from 26 weeks to 104 weeks. You need to ensure that you amend the maternity and adoptive leave policies to include the access to maternity leave or adoptive leave for transgendered males, and ensuring that your contracts of employment include a clause on the right to request flexible working in accordance with the Act. So that will be one clause relating to flexible working for caring purposes, and a second clause in your contract of employment in relation to the right to request remote working, sort of caveated with the fact that we do await that code of practice. So in that regard, I know there's a lot of information there, and I'd love to open up the floor for any questions that anyone may have. So if anyone wants to put a question into the Q&A function, I will be more than happy to provide any support in relation to that. Okay, nothing appears to be coming in. As strategic partner with Fingal Chamber, Kildare and Oireachtas Down, if you have any follow-up questions, I appreciate you may not have them right now, but certainly in the coming weeks in relation to any aspects of the new legislation or any guidance, please feel free to reach out to us in Adare, info@adarehrm.ie, and the phone number is on the screen there in front of you. I want to thank everyone, and in particular Anthony, thank you so much for your introduction. It's always a pleasure for us to do these types of webinars to ensure that members are being informed in relation to the latest changes in employment legislation. We have had a question just in relation to the slides, and absolutely more than happy to provide a copy of the slides to all attendees. Apart from that, I want to thank you again for taking the time to join us this morning, and we will see you again soon.